Thank you for joining the Information Technology Industry Council's discussion today about EU-U.S. data flows after the Schrems II decision. My name is Rob Strayer. I'm the Executive Vice President of Policy at ITI. I want to have a special welcome for our panelists, expert panelists, two of whom are from government. I'm going to provide a little bit of context, and then we're going to turn it over to a panel discussion. I think as probably everyone joining this discussion knows, cross-border data flows underpin global trade and are critical to the global economic growth. Data flows are fundamental to the transatlantic trading relationship, which is the largest in the world, and it's valued at more than $1.3 trillion annually. That supports more than 16 million jobs on both sides of the Atlantic. And transatlantic data flows continue to be the fastest growing in the world, representing more than the transatlantic nature of them represents more than 50% of Europe's data flows and about 50% of US data flows. The EU-U.S. Privacy Shield and the standard contract clauses are essential mechanisms for international business operations. They enable cross-border data flows and innovation while providing clarity on privacy protections and robust commitments as required by law. The invalidation of Privacy Shield has created legal uncertainty for more than 5,300 Privacy Shield certified organizations. Disruption of the ability of these companies to confidently transfer data from the EU must be avoided in order to minimize any negative economic consequences. This is particularly a concern in the wake of the COVID-19 crisis, and as we hopefully enter the economic recovery phase in both Europe and the United States next year. ITA welcomed the European Court of Justice ruling upholding standard contract clauses as a valid transfer mechanism. However, the decision created questions about the long-term viability of these mechanisms. In the immediate wake of the decision, ITI emphasized the need for the US and EU governments to work together to ensure the continued viability of SCCs. It is important to recognize that the stability of SCCs is not just a problem for tech companies or the privacy community, but it's an issue for companies of all sizes across all industries and all geographies that rely on international data flows to conduct commerce or employ a multinational workforce. To address the core concerns of the ruling, ITI recommended thinking about both short-term and long-term solutions. In the short term, the solutions should focus on pursuing an enhanced transatlantic privacy framework addressing concerns regarding US national security authorities, data, and the lack of adequate redress rights for EU citizens. Another short-term solution can be provided by the European Commission's and the European Data Protection Board's work to develop new model SCCs that offer supplementary safeguards for data. In the long term, the solution likely involves making progress on an international pledge or agreement regarding best practices for surveillance, government access to data, privacy, and data transfers that can eventually garner global consensus. Since the release of the Schrems II ruling, ITI has led global industry letters with several European and other US trade associations to the European Commission, European Data Protection Board, and US government to urge both sides to swiftly negotiate enhancements to Privacy Shield to address the proportionality and redress elements of the Schrems II decision in order to restore viability of Privacy Shield and to stabilize the SCCs and other transfer mechanisms. ITI has been and continues to be in close contact with the Commerce Department and other US government stakeholders, as well as European Commission officials, members of the European Parliament, member states, and data protection authorities to discuss the implications of the ruling and potential paths forward. ITI also is in regular contact with key US House and Senate lawmakers, as well as their staffs to brief them on the impact of this decision on US large and small businesses. ITI welcomes the interagency collaboration in the US government to provide much needed guidance to the thousands of companies impacted by the decision seeking to lawfully transfer data from the EU. The white paper published by the Departments of Commerce and Justice, along with the Office of the Director of National Intelligence, serves as a useful guide to US national security practices while pointing to up-to-date privacy safeguards. ITI also thanks the European Commission and the European Data Protection Board for launching public consultations on the draft SECs and supplementary guidance. We appreciate the effort that goes into drafting those comprehensive documents. Many, if not all, of our member companies from the US as well as Europe and other regions will be significantly impacted by the final model clauses and guidance. As the consultations continue, we encourage the Commission to consider the interests of all stakeholders impacted by cross-border data flows, including public authorities, law enforcement, consumer groups, academics, and research bodies, in addition to the supervisory authorities in industry. ITI recommends that the Commission facilitate a smooth transition to an enhanced or successor Privacy Shield agreement and new standard contract clauses by providing sufficient transition periods for their implementation. We recommend that the European Data Protection Board draft guidance align itself with the GDPR's risk-based approach, in that it would also be risk-based and reflect the Commission's primary role in assessing adequacy of third country data protection regimes. We also encourage the use of organizational and contractual safeguards alongside technical measures as approaches that are pragmatic while still aligned with the ruling. ITI stands ready to work with stakeholders across governments, the business community, and civil society to develop policy frameworks that protect citizens' personal data while supporting innovation and free flows of data. With that overview, I'd like now to turn it over to our panel, which will be moderated by John Miller from ITI, who is our Senior Vice President for Trust, Data, and Technology. Over to you, John.
Thanks, Rob, and thanks everyone for joining us this morning or this afternoon if you're in Europe, or perhaps even this evening if you're dialing in from Asia. I think everyone always says at the beginning of a panel we have a great panel for you today, but we really do have an excellent panel of experts who I'll briefly introduce because it's hard to imagine a better group to talk about this set of issues than the folks we've gathered here today. And I'll introduce them in the order that of their initial interventions. So first we have Alex Greenstein, who has served as the director of the EU-U.S. Privacy Shield program since July 2019. He is responsible for management and administration of the Privacy Shield program, as well as policy regarding transatlantic data privacy, data flows, and digital trade issues. Prior to joining the Commerce Department, Alex served as a senior advisor in the Office of the Coordinator for Communications and Internet Policy at the U.S. Department of State, and also previously served at the White House as both a senior policy advisor for economic and technology policy at the National Economic Council, and also prior to that served in the White House at the National Security Council, where he oversaw negotiation of the EU-U.S. Privacy Shield back in 2015. Next up, we have Ralph Sauer. Ralph is the Deputy Head of Unit in DG Justice and Consumers International Data Protection Unit at the European Commission. He is responsible, along with the head of unit, for the entire work of the unit, which covers data flows both for commercial purposes and in the area of law enforcement cooperation. The objective of the unit is to facilitate such data flows through multi and bilateral arrangements at the international level while ensuring a high level of data protection. He has also been one of the key negotiators of the EU-U.S. Privacy Shield and has been centrally involved in the annual review. Next, we have Nathalie Lanare, who is the Director of Privacy Policy at Hunton Andrews Kurth's Center for Information Policy Leadership, a preeminent global privacy and security policy think tank located in Washington, D.C., London, and Brussels. Nathalie brings more than 20 years of experience in data protection policy, both in-house and in private practice. And she, in her current role, works on global public policy initiatives and develops and maintains relationships with relevant regulatory authorities in Europe, among other projects. And prior to joining CIPL, Nathalie was a group data protection officer for Capgemini Group, and so certainly and has held several other positions of note as well, and can certainly bring the perspective of a DPO amongst other things to the discussion. Theodore Christakis is the professor of international and European law at the University Grenoble-Alpes and distinguished visiting fellow at the New York University Cyber Security Center. He is the director of the Center for International Security and European Studies and co-director of the Grenoble-Alpes Data Institute. He's also a member of the Institut Universitaire de France and one of the French National Digital Council and a senior fellow with the Cross-Border Data Forum. He also holds a chair on the legal and regulatory implications of artificial intelligence with the Multidisciplinary Institute on Artificial Intelligence. And as anyone who has been following the Schrems case since July knows, he's also a very prolific writer on all of these issues. It is sometimes hard to keep up with Theodore's posts, and indeed, just this morning, he has published a new study called European Digital Sovereignty, Successfully Navigating Between the Brussels Effect and Europe's Quest for Strategic Autonomy. We will try to share the link to that in the chat, and I'm sure that Theodore will be happy to chat about that new study today. And then finally, we have Peter Sauer, who is the Elizabeth and Thomas Holder Chair and Professor of Law and Ethics at the Georgia Tech Scheller College of Business and Associate Director for Policy of the Georgia Tech Institute for Information Security and Privacy. He's also a senior counsel with the law firm Alston and Bird. Peter has many accolades and accomplishments, just a few of note. In 2018, Peter was named as an Andrew Carnegie Fellow for Research on Protecting Human Rights and National Security in the New Era of Data Nationalism. He previously won the International Association of Privacy Professionals Privacy Leadership Award in 2015. In 2013, he served as one of 5 members of President Obama's review group on intelligence and communications technology. He co-chaired the Global Do Not Track process for the World Wide Web Consortium. And oh, by the way, under President Clinton, he was a chief counselor for privacy, the first person to have a U.S. government-wide responsibility for privacy policy. So, as I said, we're in great hands here today. Let's get to it. Why don't we start with Alex? Alex, we know that the U.S. and the EU initiated discussions regarding an enhanced privacy shield framework back in August. Can you provide an update on the status of the negotiations and share anything else you'd like to with your fellow panelists in the audience at the outset of the discussion?
Yeah, sure. No, thanks, John. Also, let me just say that, I know we've actually been in intensive discussions with the commission, and good to see you this morning, Ralph. Since even before the Privacy Shield decision, we were certainly doing a good deal of contingency planning and sort of discussions ahead of time. But then, yes, back in August, I'm sure everyone saw the sort of joint statement between Secretary Ross and Commissioner Renders announcing our commitment to work to identify sort of new enhancements to Privacy Shield that could address the court's concerns. And certainly I think that, these discussions have continued over the intervening months and recently have intensified, and sort of we're just definitely having sort of more concrete discussions about what enhancements we can make to sort of Privacy Shield to fully address the court's concerns, because certainly it's not a valid transfer mechanism right now. However, we recognize the sort of significant impact that this has had on transatlantic commerce and on the uncertainty that this has brought in for companies on both sides of the Atlantic. And so we're definitely committed to working to put in place these enhancements in an expeditious fashion. We'll move sort of as quickly as possible on this. I think just sort of more broadly, I mean, I can't go into sort of the content of the discussions that we're having right now and sort of what these enhancements might look like. However, I mean, I think this more broadly, and I'd like to say this at the outset, has underscored the need for a broader discussion amongst democracies about the issue of government access to data. And so this is something that I think Schrems 2 and sort of the aftermath of it, I think is serving as a moment to sort of catalyze this discussion. And yeah, so to minimize future disruptions to data transfers, we are engaging with the European Union and other partners for multilateral discussions about common practices for addressing how to reconcile law enforcement and national security needs for data with sort of the protection of individual rights. And so this is something where we definitely welcome sort of like the sentiments you expressed earlier about sort of the need for democracies together to articulate shared principles regarding government access to personal data and to sort of make a clear distinction between sort of the practices that you see in the United States and Europe and those of authoritarian countries. And so I think this is sort of something also that highlights the fact that there is a great deal of commonality between sort of the United States and Europe on this issue, and that we are working in partnership with the Commission to try to address these challenges.
Thanks, Alex. A lot to consider there, and I'm sure we'll come back to some of that. Next up, a question for you, Ralph. Your team at DG Justice has been busy on several fronts, including not only the enhanced Privacy Shield or Privacy Shield successor negotiations that Alex just mentioned, but also the recent proposed revisions to standard contractual clauses. The comment period just closed last week. I'm wondering if you've even had a chance to start reviewing any of those submissions, but even more fundamentally, can you speak to the Commission's approach to revising the standard contractual clauses, particularly in light of the Schrems 2 decision? Are there any takeaways from your preliminary assessment, and do you have anything to add to what Alex said regarding both the negotiations and the need for a longer-term agreement? Thanks.
Yes, thank you very much for the question, and first of all, hello to everyone. Good morning, evening, and good afternoon. On the standard contractual clauses, first of all, I think it's important to note that we are modernizing these clauses not just because of Schrems 2, which is already shown by the fact that we started actually much earlier on this, and the reason is, of course, that we have a new law in Europe, which hasn't changed everything, but it contains some important changes from the previous data protection regime. So although the existing or the old model clauses were in a way grandfathered into the new system, there is still a need to adapt them to the GDPR on some points. For example, the controller-processor relationship, for which we have now an entirely new provision in the GDPR. So that was one obvious reason. Another one was that the digital economy has moved on since these clauses were developed, because they date back, some of them, to the early 2000s. So there was certainly a need to look at them again, see whether they fit the needs of the digital age. And there was also a clear need to fill certain gaps, because as we all know, the current SECs don't address every transfer scenario, and since they're so important, since we're guessing that more than 80-85% of data transfers are carried out on that basis, it's of course important that they cover at least the majority, the overwhelming majority of transfer scenarios. So that's also a reason for the modernization. And then Schrems 2, or more generally, the question of how to address government access was the third one. And so to pursue these various objectives, we have restructured the SECs in the draft that we made public. We have gone for what we call a modular approach. So within one structure, where certain things are common to all types of transfers, there are specific modules that address the specificities of some of the transfer scenarios, and where you then see certain differences. We have tried to open up the SECs to multi-party constellations, and of course, as I said, we have made certain changes that follow from the development of our legislative framework, but also development of guidance in that respect, and so forth. So that's that was the let's say the driving force behind this modernization. The public consultation period has just closed, as you say. So we have not been able. We have received something like 150 submissions, which we'll now go through and look at carefully. But obviously we have not been able yet to do that. But we had a couple of stakeholder events in various settings, and so at least from that, I think I can point to some let's say issues that or questions that have come up that concerns the indeed these modules and more specifically which transfer scenarios are covered. What we can see is that I think there's a bit of confusion that has been created by the fact that we say in the model clauses, in the draft clauses, that we only cover transfers to recipients, let's call them, that are not covered by the GDPR, and this has raised questions or suggestions have been made whether with that we have taken a position that if on the receiving end there is an entity which directly falls under GDPR, whether we don't consider that a transfer, which is not the case. It's just something which on which there is still not full clarity, and clarity both as to whether that is a transfer and clarity also as to what additional safeguards in a way we could put in place in a scenario where the recipient is already subject to all the requirements of the GDPR. So that's one topic that has come up. The processor to controller relationship is one which I think still raises questions, and where we have seen certain suggestions to do more or to do less in terms of the requirements that would be imposed in that scenario on the foreign controller. Joint controllership is also one of those issues. So a number of questions around the, let's say, transfer scenarios that we cover. Government access is obviously one, and there you have the direct link to the guidance from the European Data Protection Board. We all know that there is a quite lively debate, I would say, around the question of what do you have to assess, or what should the assessment focus on? Is it only the question of whether the recipient of the data falls within the scope of application of certain laws in the third country that allow for government interference, or is it also relevant sort of how likely that is? So that's the whole debate around bringing in the risk-based approach also in that context. We obviously want to ensure that there is a full alignment with the interpretation given by the European Data Protection Board. The European Data Protection Board has given a rather restrictive, but their guidance is also up for public consultation. That public consultation is still open, so we will certainly see whether there will be any evolution also in the guidance that comes from the European Data Protection Board. But that's certainly something which is also on the mind of many commercial players in particular. Also in that context, the cooperation with the data protection authorities for supplementary measures, and to some extent the question of the legal challenge of disclosure requests. All these things are related to government access, and there's, as I said, a lively debate around this. And then there are more, let's say, many technical issues. One which I think is quite important, which is the so-called docking clause. So that's the clause which would allow, first of all, to have multi-party constellations, and also would allow for a subsequent enlargement, in a way, of the group of parties to such a contract. And there are many questions around how this should be done technically, and how it could be facilitated. So we'll also have to look into that. And then maybe onward transfers is also a last point just to mention. So the question of what are the available instruments for an onward transfer, which means a further transfer from the recipient to yet another country, or at least to an entity that is not within the scope of application of the GDPR. So just to say, I mean, it's a large number of points that are raised. Obviously, also not all going in the same direction. So on the same clauses, we have comments going in both directions or contradicting each other. So we'll have an interesting time in looking into this, balancing the interests at stake. But to my mind, all of this is extremely helpful, and I think will help us to further increase the quality of these model clauses. Generally speaking, I think the feedback is rather positive. I'm not just saying this because I'm coming from the unit or the department that worked on this, but I think that is my impression. But still, as always, there's room for improvement, and so we'll look into that. On the privacy shield, or rather sort of the transatlantic relationship and data transfers in this, Alex has already said a couple of things on that, so and I agree with this, so I don't have to repeat that. I think we share the view with our colleagues in the United States that a comprehensive solution through a strengthened framework for data transfers, which could then be the basis for an adequacy finding, is the preferred solution in terms of facilitating data flows, in terms of legal certainty. Which means we are willing to engage on this, and we have made this clear. My Commissioner Reinders has made that clear in a joint statement together with Commerce Secretary Ross. But at the same time, I think we have also made clear, and actually that joint statement makes it clear, that there cannot be any shortcuts. We on our side certainly need to ensure compliance with the requirements set in the judgment. As you know, this is not the first invalidation, it is the second invalidation of an adequacy finding. And we certainly cannot afford, will not afford a third invalidation. So it's important that we look into, I mean, carefully into what the judgment sets as requirements, and I think those are two things: the limitations as regards collection, so questions around the clarity of the rules, their proportionality and enforceability by individuals, and individual redress. So the question of redress through a body that is not necessarily a court, but has a similar autonomy and independence as a court, and the powers of investigation and correction, and before which individuals can invoke the limitations and safeguards that exist with respect to government access. So enforceable rights is obviously also part of that's I think the program, so to speak. We believe that our US colleagues are best placed to tell us what they think is feasible, legally feasible, politically feasible, of course. And then I think on that basis we can discuss and these discussions actually and exploratory talks have started, and I think that's a very good thing, and they will continue probably with a bit greater speed than once the transition period is over. And maybe the last point, I think we also share the view to the need for a more global debate. So what Alex mentioned earlier, and we agree that I think like-minded countries that share values like the US and the EU should drive that discussion. And we should work on global standards for government access, and there is some work that has started at the level of the OECD. There's also some work ongoing at the Council of Europe, and I think all of this is very good. And if we can come up with global standards, then indeed that will also help us to maybe more clearly distinguish between like-minded countries and other more authoritarian countries that pose a risk to privacy and other fundamental rights. So I think, like Alex, I have my limitations as to the details of the discussions, but just to confirm, we are in exploratory talks, and I think we share the same sort of approach and baseline. But of course, it's not going to be easy. It's a difficult judgment to deal with, and I think it will take a bit of time to work through this. But I'm confident that we will succeed on that. Thank you.
Thanks, Ralph. I'm getting a little bit of an echo now, but okay. Let's go to Nathalie next. And if you're not speaking, you can mute your mic, so that'd be great. Certainly a lot to consider from what Ralph just said. Nathalie, I mean, certainly I think you are the perfect speaker to come next, though, because your organization, CIPL, has been quite focused on the practical aspects of this set of issues. You published practical recommendations on data transfers after the decision. You can also bring the perspective of a former data protection officer. Ralph also alluded to the European Data Protection Board guidance, which is further kind of complicated or clouded the picture here. Can you elaborate on some of the practical difficulties companies may soon be facing, in using standard contractual clauses, particularly in light of that EDPB guidance, which, as was previously stated, is fairly restrictive?
Yes, thank you, John, and thank you, ITI, for having me this morning and this afternoon. Very happy to be here. Indeed, CIPL has worked extensively on this, and we have, of course, responded to the EU Commission consultation, and we are preparing to respond to the EDPB recommendations. So today, as you said, I'm going to focus first on the challenges, but also I want to bring a few elements of opportunities to go forward, because we have to be optimistic. Things are going to work better, and that we're not going to be facing huge business disruption. So as part of the challenging, and every time I will distinguish between the substantive elements and then the more of the oversight and enforcement aspect. So in terms of the challenges, of course, we'll be talking more about this, that there's big lack of consideration of the risk-based approach into the EDPB recommendation, and it is leading the EDPB in some of the use cases. It consider that there are no possible supplemental measures that could enable data transfer, which is not the way it is supposed to be working. Second, in some of the use cases of the European Data Protection Board, They recommend some technical measures that are totally unworkable for companies because they assume somehow that companies have access to highly confidential information that only government can have. For instance, at some point, they're required to adapt those technical measures to some of the crypto analysis that the foreign agency, the capabilities of foreign agency would have on crypto analysis, which is totally impossible for a private organization, not even mentioning, of course, the smaller, but even the big ones would not be able to achieve this. On a more practical perspective, of course, I want to mention this, of course, as a former DPO, it's a huge amount of work, right? It's not just going through a list of technical measures, it's really redoing risk assessment, it's really setting up a whole project. It's really revamping some technical architecture. It's not an overnight exercise. And of course, and this is more for maybe the SCCs, this involves third party, right? It's not a unilateral exercise. You have to go back into discussion. You have to go to your procurement department and tell your head of procurement, I'm sorry, but I think we're going to have to reopen those discussions because SCCs are always part of the broader commercial relationship. They are not self-standing agreements, right? They exist for one reason. And here we have the new SCCs that require organizations to provide warranties, to do their best effort to provide as much information as possible on things they have no control on. So I think we really need to work on this also to make this realistic for companies who cannot be forced to give warranties to something they don't control. As part of oversight and enforcement, of course, the challenges are that the recommendation of the EDPB are immediately applicable, that the SCCs only provide for 1 year time a period for organizations to update all of their agreements. And in some companies, it can be tens of thousands of agreements. And lastly, on the challenges, the SCCs provide also now for an obligation for companies when they realize that the SCCs are not enough to notify data protection authorities. And I think with that, we're really going backwards because with GDPR, we had moved to a situation where actually organizations were not required anymore to go to the data protection authority every time they wanted to transfer data abroad. And with that, we brought the accountability principle. And putting this back into the SCC will make us really go backwards and back into some form of bureaucracy that is really counterproductive. But there are opportunities, of course. So, of course, as part of the substance, well, the big opportunity is somehow for all of this to apply, a famous concept that is very much known under US competition law, which is we have to apply a rule of reason to that. Right? And that means go back to the risk-based approach fully as it is embedded into the GDPR. That means take into consideration the likelihood and severity of risks on individual to make those assessments. Take into account the past history of government access to the data. Take into account how much the national foreign authorities are interested in some specific type of data. And I can assure you that going this way would enable resolving almost, or maybe more than 90% of the cases, really leaving the most problematic cases for further resolution. And the same should be for the SCCs, where some clauses of the SCC require the data importer to systematically challenge those requests. These should be also be based on risk, so that it is limited to those requests that are most excessive and not in compliance with EU law. And of course, as part of the enforcement for the opportunities, well, I mean, to the extent possible, an enforcement moratorium like we had when the safe harbor was invalidated would be very much welcome. And also risk-based approach to enforcement itself by data protection authorities, not going through after each and every problematic transfer, but taking into account also the risk and the risk harm to individual and the level of potential damage. And this is actually in Article 83 of the GDPR as part of the conditions that data protection authorities have to take into account. There are some challenges, but I think that are also some opportunities, and really we should leverage all the leeway that GDPR affords, and in particular as part of the risk-based approach to make this work for companies. Thank you, John. I think you're on mute.
Thank you. Thank you very much, Nathalie. I was just saying, you know, several of the risks and opportunities that you pointed out were actually are echoed by ITI's comments that we also submitted on the standard contractual clauses, particularly the opportunities created by embracing the risk-based approach and some of the more problematic, you know, elements of you know, compliance under a 12-month, you know, full compliance under a 12-month time frame. So thanks for that. Next, Theodore, I think you are back on. Hopefully you're not experiencing technical difficulties. You know, as mentioned previously, you've certainly done a lot of writing since the Schrems II decision, talking, you know, not only about the constitutional implications of the judgment for Europe, but also the European Data Protection Board's recommendations on supplementary measures, and the other document they published, which has flown under the radar, the essential guarantees for surveillance. You know, as I mentioned at the outset, you also published another study earlier this morning on European digital sovereignty. And I think in that, I have not had a chance to read that yet, apologies, but as I understand it, you're certainly addressing the Commission's draft standard contractual clauses, as well as some other broader EU digital policies. You know, I'll just leave it to you to you know, to share some of your thoughts on these topics. And you know, particularly the impacts, you know, kind of at the conflict of proportionality in the surveillance conflict, in the surveillance context, and cross-border data flows.
Thank you very much, John. I hope that you can hear me, and thanks,
yes.
Many thanks to IT for having me. And indeed, it's a great coincidence that after months of work, I have published today this big study. It's more than 100 pages on European digital sovereignty, which is an absolutely crucial concept in relation with all these discussions. It goes much further than international data flows. I discuss a lot of things in this study, and you have shared the link in the chat. But I took advantage of the fact that I was updating the study after a workshop where we discussed this with a big think tank in Paris, in order to introduce a kind of fourth part in my European law blog posts on Schrems II, especially focusing on data localization. I would like to present you here some thoughts which are in reality directly linked to what my predecessor said. I heard very carefully Ralph discussing the process of negotiation for the new arrangement, and he said no shortcuts this time. He spoke about the need to do it right for a long-lasting solution, and this was also Alex's message, that democracies should be able to find the way to find solutions for this and to address all these concerns. And we all know that the European Union a few days ago offered the new administration, the new Biden administration, and said that it's absolutely capital to have transatlantic agreements on all these tech issues. So Omer Tene, immediately after Schrems II, launched a poll on Twitter for the new name of after Safe Harbor and Privacy Shield, and the one which won was Last Chance, the name Last Chance. And I think that Ralph said exactly this. So one of the issues that we're thinking also with Peter, who will talk after me, was how to be able to help this process, because we are confident that this could work. that the issues addressed by the Court of Justice could work, and that there is a real need for a long-lasting solution and long-lasting arrangement. And this is exactly what Ralph said. He also talked about global standards. So for all this, we need to buy time somehow, to buy time for the negotiators to do their work correctly, because we cannot do this in 1 or 2 months. There is a continuation on all these issues in the U.S. administration. So I would just like to offer some of the thoughts that I share also in my study. Basically, I would like to continue from where Nathalie stopped with this risk-based approach, because I read some of the submissions to the Commission's survey on the draft SECs, and it is very interesting to see that some NGOs, like None of Your Business, challenged the possibility to adopt a risk-based approach. They said that this is nowhere to be found in Article 46, so this is not compatible with the GDPR. And I would like to discuss a little bit this, but let me start a little bit before, which is my basic conclusion in all this post in the European Law blog was that if you join the conclusions of these two documents, the two guidelines, Ralph said it was a restrictive interpretation. He said this diplomatically. The answer is, the solution is that regular transfers to third countries are almost always unlawful if the personal data can be read in the third country. Because as I wrote in my paper, and I'm working on surveillance issues for years, very few countries to meet these very strict standards, which is very disappointing, by the way, if I might say this as a European, because I'm fully committed to the work which is done by the European courts on these issues. Surveillance techniques are becoming scary, and it's good to have judges who are trying to update human rights standards in order to be able to deal with these issues. So the problem, nonetheless, is that for the time being, I mean, in the 20 years of the Commission, we only have 8 adequacy decisions with sovereign countries. I will not talk about the 4 other entities, only 8 countries, and we could also wonder if all these 8 countries really meet the EEG standards. So if we join the two documents, the result is that you cannot transfer readable data in a third country because no country will be able to meet the standards. And that means that finally this leads to data localization. The European Data Protection Board does not say this directly, but the only way, the only implication is that if you cannot send data readable out of Europe, the only way is to keep them in Europe. And this reminds us of the fact that some DPAs, like the one from Berlin, the Berlin Data Commissioner, said at that time of Schrems 2 that now it's the time for Europe's digital independence. And in my study, I examined precisely how the DPAs, some DPAs at least, the European Data Protection Board, is lending such strong support to calls by some policymakers in Europe, not all of them, I will come back to this, to introduce data localization. We know that Thierry Breton, for instance, on several occasions has said, and I quote, "I have always said that I want Europeans' data to be processed, stored, and processed in Europe. The Chinese and the Russians are doing it. We will do it too." And it's interesting because here in a lot of discussions about digital sovereignty, some proponents of digital sovereignty were very happy with the EDPB guidance, and they said, I quote, "It's an opportunity as we have rarely seen in history for Europeans to regain control of their digital sovereignty and for European cloud providers and startups in Europe." Which is what strikes me very much is that these declarations from proponents of a strong version of digital sovereignty absolutely contrast with the position of business organizations in Europe. And if you see the submissions of several European business organizations to the Commission's SEC's draft, you will see, for instance, I take precisely in order to contrast French for French, the major French organization, which is the MEDEF, submitted a document which is extremely critical of the EDPB guidance. They talk about a very restrictive, unrealistic guidance, and I quote the submission, by recommending measures that are not feasible in practice, especially for very small and medium-sized business that do not have sufficient resources, the development of French and European companies internationally is hampered. So this means also, there was a study published a few days ago by 4 major pan-European business organizations, which showed that in reality, it's 75% of companies using SECs for transfers of data out of Europe are European, against only 13% of US companies. And they concluded, and I quote, that it seems to us that in its current form, such guidance could make it very difficult for business to rely on SECs. This is not only in conflict with the European Commission's new draft set of SECs, but even with the Schrems II decision itself. And I would like to frame correctly the issue. The issue here is not whether economic considerations should take precedence over data protection requirements, or whether economic utilitarianism and efficiency should be the measure of legal rules. The real issue is how to assess whether strict restrictions to transborder flows of personal data and data localization are necessary and proportionary response to existing risks. And as Nathalie said, the problem with ADPB guidance is that it is entirely neglecting this risk-based approach and the principle of necessity and proportionality. It is based on the idea that even if a very small risk exists of a foreign government, just a theoretical risk of a foreign government accessing a specific category of data, then data should not be transferred in a readable format. And I give an example in my study today of a European company where DPOs work very hard to protect the data. They have never received a FISA 702 request. And they are based also on all this practice on the white paper published by the US in September 2020. And they say, hey, listen, if for human rights resources data, which, I mean, the risk is extremely limited, probably you can use other kind of measures, supplementary measures, not encryption, because it makes no sense. We need the data to be accessible. And if we ever receive suddenly, surprisingly, in the future, a FISA 702 request, then we'll stop everything. Or if we learn that other companies in our position, this could make sense. This could appear as a logical solution in conformity with Chapter 7 of the GDPR, but the ADPB clearly prohibit such intra-group transfers of readable data under use case 7. And now none of your business comes and says that nothing in Article 46 indicates that the transfer may take place when it presents a low risk. Well, this would lead to the spectacular conclusion that even if there is a 1 in a million risk of foreign access in a specific case, and even if this negligible risk can be addressed by other less severe supplementary measures, no data transfers can take place. And suddenly the principles of necessity and proportionality, which we'll find everywhere in human rights and data protection law, will not be applicable anymore for Article 46 of the GDPR. One could consider, on the contrary, that if the legislators wanted to prohibit any kind of transfer of readable data when there is no adequacy decision or essential equivalence, they would have clearly said so in Article 46. And I have the feeling that with this extremely restrictive guidance, the ADPB is about to kind of rewrite Chapter 5. For me, it will basically make Article 46 redundant, since the Article 45 standard of adequacy and equivalence will be the only one. We don't need Article 46 or Article 47 anymore. So in my study, and I will conclude, John, precisely I focus on the principle of necessity and proportionality that should be reintroduced. And this is, Ralph talked about the OECD process. We have something very useful in the OECD. We have in the OECD privacy guidelines, we have a kind of gold standard to assess if restrictions to border data flows are justified in a specific situation. They say, I quote, any restrictions to transborder flows of personal data should be proportionate to the risk presented, taking into account the sensitivity of the data and the purpose and the context of the processing. So in my study, I advance a series of ideas in relation with this principle of proportionality that should be reintroduced for me in the EDPB guidance in compliance with Schrems II, because we'll be able to protect data, And I also quote, paraphrase Justice Jackson's famous quote in the US Supreme Court when he said that it could be useful to dilute doctrinal logic, or in our case, an exclusively rights-based approach, with a little practical wisdom, or in our case, a risk-based approach, because the GDPR is not a suicide pact. So I think that if we introduce this possibility of a risk-based approach proportionate, and we keep the strict measures recommended by the EDPB for high or medium risk situations, while allowing for data transfers to continue to take place for low risk situations, which, as Nathalie said, it's the great majority of data transfers to the United States, this combined to other measures like the ideas which have already been presented by Peter, for instance, the non-statutory guarantees for judicial redress, things that could be done quickly. I don't say that this will fix the problem. This will not be an Article 45 solution, but it could provide all necessary time to the negotiators without having a total disruption. I think it will be very unpleasant for the new administration that will arrive in January to arrive in a situation where there is total disruption, there are no data transfers anymore, and I wonder how they will be able to deal with all this. And in order to conclude, I will quote Ralph, or his boss, Bruno Gencarelli, who said several times, like many other persons in the Commission, that they have emphasized that Schrems 2 should not usher in an era of data localization. That has not changed, said Ralph, with a judgment. We believe in free data flows. And Bruno Gencarelli in several conferences recently repeats constantly that data localization has not been in the GDPR's DNA. Margaret Vestager also insists that it's important that data can travel into and out of the Union. Thank you very much.
Well, thank you for that, Theodore. Certainly a lot to consider there. Actually, I see it has generated at least one comment in the chat. But before going to Peter, I do want to encourage folks, if you do have questions, you can put them in the chat, or you could maybe raise your hands or just indicate once we open it up to Q&A. But Peter, I'm sure you have a lot of thoughts on what you've heard from your fellow panelists already. I certainly don't want to foreclose you commenting on any of it. I know you also have done a lot of work. I mentioned a couple of times Theodore is quite prolific. You are as well, that's for sure. You in particular have done a lot of thinking about redress and that topic, as Theodore mentioned. But yeah, I mean, it would really be great to get your thoughts on anything you've heard. But in particular, if you can provide any insights as to what you think, a successor or enhanced privacy shield agreement might contain regarding redress and proportionality, I think that would really round out the opening round of comments here. Thanks.
Thank you, John, and thanks to everybody. What a great set of discussions already. It's been a pleasure at the Cross-Border Data Forum to get to know and work with Theodore, who, as you see, was writing about the risk-based problems within a day, publishing after the EDPB guidance, and has been such an expert on the EU side. And I'm going to try to make some comments on the US side, because I started as an American lawyer and not try to presume to pretend to be a European lawyer. For American lawyers, clearly there's two legal challenges under Schrems 2. One is judicial redress, and the other individual redress, and the other is proportionality. And with Kenneth Propp, who's a former State Department lawyer, we published a proposal on redress back in August. It got some expert testimony from experienced EU lawyer Christopher Doxey after that. And in my testimony in the US Senate Commerce Committee last week, I tried to go through some ways, even without a statute, that really significant safeguards could happen on redress. So let me just try to explain that, because it gets into the weeds of some institutions people don't always think about. So the big question is, if you're a European individual, somebody in Belgium and France and Germany, and you want to see whether your rights are being protected by the US surveillance system, can you go to court in the United States and say, I have a concern here? Or can your DPA go to court and do it on your behalf? And there's a big constitutional problem under US law that's called standing, which says, as a matter of the Constitution, as a matter of Article 3 of the US Constitution, you have to show a specific individual injury in order to get a federal judge to look at your case. And so just saying, maybe I've been hurt, so I want to get redress, doesn't seem possible under US law unless we can come up with some way to do that. And so the proposal is the following. In the United States, we have had for many years, and exists in other countries, something called the Freedom of Information Act. So if I want to ask the Department of Commerce for records about me, I don't have to be injured. I just get to send in a FOIA request and say, hey, I'm a person. I would like to trigger a mandatory duty on the agency. And then the duty has to act. And then judges, federal judges, can see whether the agency acted properly as part of its mandatory obligations. And so the proposal we've made is that there can be a complaint, let's say by an individual from Europe or DPA, and it's on that person's behalf, and the complaint goes to an agency that has a legal requirement to act, to do a independent, careful fact-finding investigation. And we go through in the details how the PCLOB, the Privacy and Civil Liberty Oversight Board, and various agency people working for the PCLOB or on their own behalf, we go through different ways to do that. But by a combination of executive order, the president could write that tomorrow, and memorandums of understanding, agreements between agencies about what they take on obligations to do. The testimony last week shows non-statutory ways to create these independent fact-finding investigations by the right kind of officials under European law, by people with independence and the ability to issue orders. And then there's a second stage to redress. The second stage is there a way to have a judge or somebody who looks a lot like a judge, such as a tribunal, make the decision and issue a binding order? And the testimony last week points out that federal judges in the FISC, the Foreign Intelligence Surveillance Court, that federal judges have an annual order for the operation of Section 702. And if the Department of Justice or any other federal agency violates the judge's order, the judge has ongoing judicial oversight over the judge's own order. And it would be contempt of court and a violation of if the agencies don't do what they're supposed to do. And so for Section 702, which has been by far the greatest focus of controversy, which is where there's a surveillance of a non-US person, the surveillance happens in the United States, they go to the companies for it. For that, we have a mechanism for individual fact-finding, followed by a mechanism for judicial redress. The US system is somewhat different from the European system in certain specific ways. You can't get exact equivalence. We don't have an exact agency that looks exactly like a DPA, but the PCLOB is an independent agency with abilities to do many of those things. And so we think there's a very strong case that we have a redress system that can be built by executive action, and it could be further solidified over time by congressional action. So I think that's the part that's most surprising to people and that I just like to point out. In the testimony concerning proportionality, not only can we have protections that there is proportionality by the redress proposals, but actual looking at US surveillance practices is relevant to that. So in another appendix to the testimony on Wednesday, working with research assistants who are lawyers, we have 25 pages with 169 footnotes documenting US surveillance-related safeguards since 2016. So the Commission made its adequacy finding at the time of Privacy Shield. Things that have happened since Privacy Shield are relevant to an analysis of their safeguards that exist today. And people can differ on how large or small they think any of these actions are, but at least there's now a record with footnotes that you can look at to see what the actions are to safeguard personal data under the US surveillance system. So those are two things on redress and proportionality. Let me just briefly make about 2 or 3 other points and then I'll stop. Another point we've heard a lot about today is data localization. At the Cross-Border Data Forum, the most recent post is about a 1998 book that I co-authored that had chapters, more than 100 pages, about data localization. I don't suggest the legal analysis is up to date, but it shows 35 or 40 different categories of transatlantic data flow that existed already in 1998. That can be a list of issues for what are the problems we're likely to see today. And so that can be helpful. And we're working on comments at the Cross-Border Data Forum. I am with one of my colleagues to make other points about why data localization in practice is harder than people think it is, why there's actual sort of obstacles to localization. And so even as a matter of buying a plane ticket to go to a foreign country, or as a matter of other things, there's really large obstacles to even knowing how you could do these things under the current EDPB guidance. The last point I'll make very briefly, and that's in my testimony to the Senate Commerce Committee, is that I do think that industry and others concerned about these issues can play a constructive role in letting Congress know that Congress should pass commercial privacy legislation in the United States with significant privacy safeguards. And that will not directly address the surveillance issues, but as part of the overall relationship, as part of the sense of whether the United States is engaged in similar values and similar activities, I do think if there were significant commercial privacy legislation, there would be more room for the US allies in Europe to say that now they're dealing with a country that has the kind of safeguards in place in general that would meet European expectations. So there's a lot more, John, but I'll stop there.
Well, thanks very much, Peter, for those comments as usual. Again, first, let me just say, I see a couple of questions in the chat, which we'll get to in a moment. But if folks do want to either post in the chat or indicate that you'd like to speak, we can to ask a question. We can certainly unmute your mic. I think we just had 5 great interventions. First of all, I know that it's been a while since Alex and Ralph had an opportunity to comment, and I guess I want to just provide them with the opportunity to comment on anything they've heard from the subsequent speakers, because I know their names were referenced a couple of times. So I just like to provide that opportunity. Alex, do you have any comments on anything that you want to?
No, I just want to sort of I definitely welcome sort of a lot of the comments on here. And one thing I really like to sort of just highlight is sort of the practications for sort of companies for both U.S. and sort of European companies, and sort of the need for sort of a further risk-based approach on this, because certainly the vast majority of data transfers, as we saw in sort of the white paper that we put out, are not sort of interest to sort of the United States for national security reasons. And then also just sort of want to note that sort of in terms of Privacy Shield, I mean, 70+% of our participants are SMEs. And these are sort of small companies who don't have the resources to make this kind of detailed assessment of government access provisions. And then also finally, I'd also note that I know in terms of the HR data, I mean, this is something where this supports employment in Europe in many cases. And so this is sort of something where I guess that's sort of the cross-cutting point I'd like to make, is that sort of in terms of people and folks who are pushing sort of the discussion around sort of data localization, I think there's sort of a lack of recognition of just how dependent all our companies are on data flows. And this is sort of not unique to sort of U.S. companies. European companies also depend upon their ability to move data around the world. And there's a lot of companies who have a lot of business that is at risk as a result of this. And so that's why we're focused so much on addressing this in the context of our discussions around an enhanced privacy shield, because we recognize that we have to address the court's concerns. We also have to sort of enable these data flows again. And that's also sort of one of the things I wanted to point out, was just that the way that we're approaching the discussions here is that when we did Privacy Shield, the assurances that we gave around national security and access to data and the ombudsperson mechanism, those also apply to all other data transfers. And we're also looking at that the same way around sort of the Privacy Shield enhancements. And so it is our hope that sort of this would also not only re-enable privacy shield data transfers, but also data transfers using other mechanisms like the SECs to provide greater assurance about data flows that are so important. But I mean, consistent with sort of these strong privacy protections that we're discussing.
Thanks, Alex. And yeah, I'm glad that you flagged the point about European companies. I mean, Theodore provided quite a download of information, but one of the things that I think I captured correctly was he mentioned that 75% of the companies using standard contractual clauses to transfer data out of Europe are European, and only 13% of them are U.S. And at least it's my perspective that, at least as compared to the aftermath of the Schrems 1 decision, it seems like there's a much higher level of industry engagement amongst European associations and others about the importance of this set of issues. And I think Ralph wants to also comment. His name was mentioned by probably every speaker, so I want to provide that courtesy, and then I want to get to a couple of other questions. Ralph, did you have any comments, or do you have no comments?
Sure, but not because my name was mentioned. I think my name is rather irrelevant in all this.
Okay.
But the issues are, of course, quite relevant. Maybe starting with your last point. I mean, yes, of course, there is a lot of engagement and I guess I would say justified concerns also on the side of European business. There's no question, and it's also because it's not just, of course, data transfers to the US. I mean, I saw there was a point in the chat that there are, of course, also other countries where certainly the Schrems 2 issues can become an issue for data transfers, and that's absolutely correct. It's a judgment which happened to be on one aspect focus on the United States, although this was actually not even, let's say, the main part of the judgment, because that concerns the standard contractual clauses, which are not country specific, but of course there is an element in there because of the assessment of the privacy shield, which is transatlantic. So, but it goes way beyond that. I'm not totally convinced that one can therefore say that it makes transfers to third countries almost impossible across the board. It's not any type of government interference that creates an issue. It is disproportionate government interference. And I would also like to use that occasion to say, I mean, it's not like something which is spectacularly complex, what the court is asking for. It is asking, as I said, for a legal framework which frames government access, which ensures proportionality, so a certain balance of interest, and which individuals, including foreigners, can invoke and then redress in case there is an issue. I mean, it's that. If you look at it, maybe with a bit of if you step back and look at it like this, it's not something which per se one would expect that this creates a problem all around the world. But it certainly does create issues with a number of data transfers. But what I found is, and maybe in particular when listening to Nathalie, but then also at some point Theodore, well, we can make all these. We can express all these concerns, and I share the view that it creates quite some difficulties for business, and business needs to be helped in dealing with this situation. But at the same time, we can also not ignore the judgment, because I heard things like, I don't know, there are cases where no transfers are possible, and this is not what is supposed to happen. Well, I don't think that that's the way the court approaches the issue. I think it does consider that there might be situations where indeed a transfer is not possible if there is disproportionate access and nothing can be done about it in terms of supplementary measures. I also heard that there shouldn't be any kind of warranties or anything like this, but I think that's exactly what the court expresses when it stresses the accountability of companies, for better or worse. I'm not taking a judgment on this, but clearly this is part of what the court is expressing in this judgment, and it's not something which we can simply ignore, or there should be a moratorium when I think the court was asked about this and clearly decided against it. I think this is also something, and the reason, of course, being that this is a judgment which is a constitutional judgment based on the Charter of Fundamental Rights, and something where the court very rarely, I think, gives a moratorium. So, I mean, just to say that there are certain things which we just cannot ignore, and when it comes to the risk-based approach, as I said, I think it is something which one needs to consider whether the court judgment leaves that space. I don't think it helps to just say the GDPR is risk-based. I mean, first of all, it's not risk-based across the board. It's risk-based with respect to certain obligations, but there are certain fundamental obligations which are not risk-based at all. And of course, the question is, and I think one has to at least grant that our data protection authorities, I mean, they see a judgment which is quite strict, is not obviously giving that space for a risk-based approach. Maybe there are things in the judgment when the court, for example, says that what one has to assess is whether the third country law makes compliance by the recipient impossible. Maybe that is something where one could consider whether something which is very, very unlikely to be applied makes a compliance with the appropriate safeguards impossible. Maybe there are these openings, but it's I think one cannot say this is obvious from the judgment that this is built into the judgment. And I think the other important point is it's also not obvious how you would distinguish the low risk from the high risk cases. And I think that is a very important aspect, which I think an enforcer has to think about. How do you distinguish the two things? And how do you avoid that every company will simply claim that I'm in a low risk scenario and therefore I don't have to do anything? So I think short of just bashing our data protection authorities, one should recognize that they have to deal with a judgment from the Grand Chamber of our highest court, which contains some rather clear language on certain things, and if one wants to see something like likelihood be built in, one better makes a good case for it, and also shows how this can work in practice. So I just want to point this out. This being said, I mean we I think on the Commission side also think that it might maybe not be justified in all cases to simply rely on whether a certain transfer falls within the scope of application of a law, but it remains a difficult interpretation to make. I also disagree that in the end Article 46 sort of disappears and there's only Article 45. That's something that Theodore was saying. I think what the EDPB has made clear is, and that's at least I think a positive a sign, is that when you make the assessment under Article 46, it is a transfer specific assessment. It's not a general adequacy assessment. What you have to look at is whether your transfer in terms of the data that you transfer, the type of data, the type of recipient that receives it, whether that falls within the scope of application of certain laws. And there will be laws which are just irrelevant. If a law allows access to subscriber information and I send content data, well, I don't have to look at that law. That's different for an adequacy finding. Or if the recipient if the law only applies to communication service providers and my importer is not one of those, well, I don't have to look at that law. So I don't think we have a conflation here of Article 45 and 46. But I totally recognize, of course, that this doesn't mean that it's easy for companies. They are still faced, I think, with a daunting task, especially when they transfer certain types of data that are more likely to fall within the scope of application of certain laws, in particular communication data, obviously. So just to I mean, those are some considerations. The last one, I'm also not entirely sure one can really say that almost all data transfers are low risk transfers when it comes to the US. I think we should not forget a bit the numbers that you see in terms of collection happening under 702 FISA, for example, the number of selectors used, and so forth. So it's this is not to say that there might not be reasons for this, justifications for that, and of course one has to compare it to the overall size and volume of data transfers. But it's not small fry either. So just maybe to also express that.
Well, thanks, Ralph. And I see that both Nathalie and Theo would like to perhaps respond to some of what you've said and jump in on these. I do want to just throw two questions from the chat on the table as well for either of them or anyone else to chime in on. I know we're running short on time here already, but one of the questions is about the risk-based approach from Romain from None of Your Business, asking about who's going to define the threshold for risks and low risk. I think Ralph was commenting on that as well, but it's a really important question because there are other EU policies that contemplate a risk-based approach. For instance, the AI initiative, for instance, right? And so figuring out what this actually means in practice seems really important. And then to the last point you were just making, Ralph, about transfers to the U.S. specifically, and the question as to whether or not they're high risk or low risk, just in light of authorities such as FISA. There's also a question in the chat from Eric Wenger from Cisco about transfers to other third countries, and I think we heard about authoritarian regimes earlier, which would seem to imply that lots of those transfers might also be high risk if that's part of the criteria. So, Theo or Nathalie, did you want to chime in, and then also invite Peter to chime in before we're out of time, but sorry.
Go ahead, Nathalie. Unmute.
Nathalie, you're...
Yes,
okay.
sorry. No, I'll be very brief. I just wanted to give the company's perspective and say that companies just not transfer data because they transfer data, right? Companies transfer data as part of a broader processing activity because they do some HR-related processing, because they need to have instant access to data from all over the world. So it's not a standalone decision. And so when they do those risk assessments are holistic. They take into account the entire processing activity. They took into account all the criteria at once. And by the way, Ralph, I just want to mention that we actually think that the EU Commission's approach is really much better than one of the EDPB in terms of doing those risk assessment. And the EDPB is trying really to help to have those different steps when you do your risk assessment. But this may help smaller companies, but this is not really how it works in real life. I mean, you look at the entire processing operation and you do some trade-offs, and honestly, it's not always either high risk or low risk. It's much more complex than this. It's gray, lighter gray, darker gray than just black or white. And in terms of who is going to do those risk assessment, well, just within the context of the GDPR, right? The GDPR says that companies have to do risk assessment, companies have to do data protection impact assessment, and companies have to implement those mitigating measures, and that the cases where you go to the regulator are really the most problematic cases, right? So it shouldn't be the new normal. Thank you.
Thank you. Theo?
Yeah, John, there are a lot of questions, but taking into consideration there is not enough time, I will only answer to the most important, which is the one for me in relation with what I said by Romain. And this issue was also addressed, it's absolutely capital. So Romain asked, who is going to define the threshold of the low risks and the high risk in the transfer, the DPAs or the controllers? In this case, will they still keep their analysis for themselves as they do for legitimate interest? And I think that this is an absolutely capital question and a very right point. And this point also was raised by Ralph. And unfortunately, when we see the abuse, for instance, of legitimate interest by several controllers, for instance, in relation with cookies use or other issues, we can understand that this is a perfectly legitimate question for an even more important issue. And I would like to say here also that the fact that I'm asking for some pragmatism and realism does not mean that I recommend to take the pressure off. I think that the pressure is extremely important, that the court made a lot of important points that need to be addressed by a long-lasting solution. And we also see some reactions, and the EDPB had something positive for me, this guidance, this very restrictive guidance, which was, it was a real shock. Till now, companies were pretending everything was okay. We're seeing lawyers on Twitter saying everything we can, what was impossible can become possible, and all these kind of things. And suddenly, thanks to the EDPB guidance, there was a realization of the real impact of Schrems 2, and we see reactions such as the one of Microsoft, for instance, who said, and this is a very interesting issue, for the first time to challenge all government requests for data of companies public sector. They try to introduce a layer of judicial control for this kind of government request, which seems something going towards more data protection and more safeguards and guarantees. To answer the Romain's questions, I definitely think, first, that Ralph said it, I mean, the situation right now is a no-brainer for companies. We asked them to do what the Commission was not able to do. So Ralph's office was wrong twice in relation with the arrangement with the United States. And not only twice, because we can add the PNR agreement with Canada, we can add the first PNR agreement with the US, which have also been invalidated by the court. And we ask companies to do this. I mean, for me, working on surveillance issues, spending hours on this, I think it's a complete no-brainer. This is the first point. Second, of course, if we introduce, and the debate is very much focused on risk-based approach, is it expressly provided? For me, it's about proportionality. You cannot ask the others only to apply the principle of proportionality. You have to apply it with this. Article 46 implies necessarily judgments of proportionality. So who is going to do it? Are we going to ask all controllers to do it with the risk of abuse? Romain is absolutely right. And this is why in my European law blog articles, I recommended that the European Data Protection Board should work hard in order to help companies with this. I guess, and I think that they can, there are some things that can be done. I guess that there are some kind of data transfers for human resources, allowing, for instance, a company, Peugeot, or Renault U.S. To be able to consult the agenda of the European members in order to fix a call. Is this really a huge risk? Is this the kind of and if they do it, if they request, I mean, we have some objective elements. If they receive a FISA 702 request, we will know it, so they can end these transfers. There are a lot of things to be done. And definitely companies need guidance. I entirely agree with Romain, and I make some other recommendations also in my study today, such as, for instance, that the United States could transform the content of the white paper into some kind of diplomatic assurances given in order to provide more guarantees and allow for exceptions with commonly accepted mechanism with the European Union. So there are things to be done, but everybody needs to work very hard. You cannot just throw the baby with bathwater.
Theo, thanks very much for that. We are over time, and we certainly haven't answered anywhere close to all of the questions here. It's been a great discussion. Peter, I think you're the only one who didn't get a second bite at the apple. If you want to, if you have any summary thoughts, or if you want to answer any of the other questions that are in the chat, but
I'll just two sentences. One is within European law, and we have great experts. Romain's worked on this, and Theodore and Ralph and others. There's going to have to be decisions within Europe as a matter of European law of how to proceed. And for the United States, there has to be a realization that many of these issues are constitutional or fundamental rights law and are not subject to the normal kind of negotiations you see in other places. So the U.S. and other third countries have to get used to the fact that there are constitutional requirements here, and any eventual stable solutions have to really take account of that. Thanks.
Thanks, Peter. Well, we're already out over time. I see that Rob is popping back on as well. I certainly would like to thank all of our panelists as well as the audience today, many of whom are still with us. Rob, did you have any final thoughts or anything? Or
nothing more, just to thank everyone for the really frank exchange of views, really thorough and helpful. And thanks, John, for the moderating. Great job.
It was on autopilot mostly with this panel. So thank you, Rob, and thanks everyone. Hopefully we can continue this discussion because clearly it is not going to be solved in the near in the coming days at the very least. We know that. Thank you. Thanks everyone. Bye.
Thanks everyone. Thanks, John.
Bye.
Bye.